Impact of Influence.
Covering true crime throughout the Southeast.
I would call that person then a public relations professional and not a journalist. Let's get back to the definition in the statute. It is one who gathers news and information for dissemination to the public on matters of public interest and significance. I think that if you are doing that as part of an operation where you are being compensated to disseminate that information, you are not fulfilling the role envisioned in the statute. Let's look at it this way. What is news? It's the information that people who are doing wrong do not want you to know. Everything else is public relations.
That is the voice of former USC professor Jay Bender. He is also a huge historian about the law and how it applies to journalists. We'll have a full conversation about that coming up. A great lesson will be learned. Hello, friend. Matt Harris and Seton Tucker, always super grateful that you spend time with us. We're even more grateful when you join in the conversation.
On Facebook at Impact of Influence and also on our YouTube channel.
And hit subscribe and get to the YouTube channel. But there's a lot of good
debate. Some of it's not good. But, I mean, I do appreciate a good debate and people who, have lots of different opinions. We accept them.
And do it civilly, and it's all great on our side. So we are going to talk about the Outrage lawsuit filed by the Beach family against Parker's Corporation. For those unfamiliar, Parker's has a chain of convenience stores throughout the South, and
gas stations attached
to them too. Yeah, and it's where Paul Murdoch bought alcohol the night of the boat crash. And so more on that in a little bit, but explain what is happening in this Outrage case.
So in a nutshell, the Beach family is contending that things that were done during the course of the civil litigation by Parker's Corporation or on their behalf caused harm to the family members of Mallory Beach. Allegations included releasing sensitive photos to the media and a campaign of online harassment. Now, the suit contends that these alleged actions were done in an effort to weaken the resolve of the Beach family to continue with civil litigation against Parker's.
Now, again, the civil litigation, the civil liability that is done with everybody that took part in any of the lawsuits, that is over. Civil's done.
Yes, a lot of people really seem confused about that on our Facebook, so we definitely wanted to clarify that. That portion has been resolved. Parker's, as well as others, have settled with the Beach family in regards to their civil liability. People are debating about the amounts. I mean, this litigation has nothing to do with that. Now, during the course of the civil litigations, Parker was pretty vocal about his contention that he did not think it was fair and that the liquor liabilities in South Carolina needed to change, and he was going to lobby for that.
And a little background on the story in case you're not familiar. Mallory Beach was tragically killed in a boating crash. It was February of 2019. Paul Murdoch was the alleged driver of the boat. He was facing charges at the time of his death. Prior to the accident, Paul used his brother's Buster's ID to purchase alcohol at Parker's Kitchen. That's why they're involved. The group of friends set out by boat from a property owned by the Murdoch family, went to an oyster roast and later to downtown Beaufort, where Paul and Connor took shots at a bar named Luther's. You probably saw some of the surveillance footage of that throughout the years. Civil liability, as we said, again, just remind you, all the civil liability for everybody involved has been settled. Now, back to the Outrage case. It's gotten contentious.
Very, very contentious. There's been lots and lots of filings, a failed mediation over the last few weeks. There has been multiple motions filed with lots of exhibits attached. Discovery, I believe, is supposed to end at the end of this year.
This year, okay. It's getting close. Now, we need to go over some articles, a couple articles that have been mentioned in court filings. In fact, journalists have been subpoenaed for depositions. Who was the...
Liz Farrell was subpoenaed, and I believe she already sat for her deposition, which lasted 8 hours. I think she said that on her podcast, Cup of Justice. Wow, that's a long time. I think, interestingly, during that deposition, the Beach attorney, Mark Tinsley, represented her in the course of that deposition.
Okay. All right.
But I guess they said it was long, and the attorney, Mark Moore, who was doing the questioning, was very aggressive. I think they call him the Badger.
And doing like questions with that Liz doesn't feel were vital to the
No,
case,
like they asked
personal
questions,
stuff, how much
personal
she
questions,
made.
how much she made, and a divorce and stuff like that.
Yeah.
Was questioning why that was necessarily relevant to this case. Mandy Matney has also been subpoenaed, but she has filed a motion to quash, which is still pending. So we don't have an answer to that as of this recording.
We'll get into what that means with Bender when we get to him in just a little bit.
Yes.
Okay, so there's a couple articles we want to talk about that are mentioned. August 2022 article written by a friend and woman who's been on the podcast a few times, Valerie Berline, was published in the Wall Street Journal. And that article says Parker hired people he described as investigative journalists. It says when asked whether he conducted a stealth investigation and what specifically entailed, Mr. Parker paused and said, quote, "Here's a better question. So what? Of course I did. Anyone in my situation would have done exactly the same thing."
So it appears as if in this article, maybe Parker is admitting to some of the tactics that the Beach family is alleging harmed them in the lawsuit.
And again, I don't know if how unusual that is or usual in a lawsuit to hire
like PR people,
firms
and
or
they hired
investigators.
private investigators were hired. I think they're actually part of this lawsuit. Lots of people do that kind of thing during
major lawsuits.
litigation that is going to be very expensive, but also where does it cross the line?
Yes.
I think that's
What do
where
you
it has
do with what you find?
right. That's what I think you have to figure out.
Right. And then what was the second article?
Okay, the second article was written by Liz Farrell, which was published in Fitz News in December of 2021. Now, this article includes something called a sizzle reel, and people are real confused because there's two videos that we mentioned. I think I had to explain it to you like 5 times.
did.
I'm like,
It's
please try to understand this, that there are
know.
two. And I put a post on our Facebook page trying to show what these two videos are. So
Now, I think that since it took me forever, I will explain it like a third grader.
okay, I'm going to try, and if I break in at any time if it does not make sense.
Okay.
First, we have a mediation video. Now, this was meant to be confidential, and it was created by the attorneys for the Beach family in preparation for an upcoming mediation.
A civil one.
In the civil trial, the liability stuff that is already settled. And in this video, it included some pictures of Mallory Beach's dead body, as well as some testimony from family members, basically trying to show what the impact of her death has had on the family.
Gotcha. And nothing controversial about that. That is
Something that is
Right.
done in lots of civil litigation.
Now, the second one is where things get a little bit more hairy. The sizzle reel is called. It's also called like a trailer.
Sometimes you hear it referred to both.
Right.
But this was meant to be. It was an internal promotional clip that was made for an upcoming documentary called Murdoch Murders Deadly Dynasty. From what it says, again, we don't know for sure, but what it says is it was not intended for public release. Mm-hmm. This sizzle reel was just to market to different places, channels or whatever.
Because you have a production house that makes content, and then the person, in cases, so somebody makes content, and then they pitch it to Netflix, Hulu, Amazon, whoever.
Right.
So that was what we gather was the case with this.
And okay, but what is really important about the sizzle reel is it allegedly includes some of the same footage that was in the mediation video. So how did these people who created the sizzle reel get this mediation video that was not meant to be public? So we have an affidavit from a woman named Vicky Ward. Vicky Ward was involved in the production of this Murdoch Murders Deadly Dynasty. Right. So she was involved, and she was initially named in this lawsuit, but has since been dismissed.
I'll read from her. The documentary was produced by Blackfin Production Company. I am neither an employee nor an owner of Blackfin. In the course of my work as a journalist gathering information for the documentary, I was provided with a copy of a video containing information related to Mallory Beach's death. The video, she writes in there with quoting fingers, I was not aware of the existence of the video until I came into possession of it. I did not specifically seek out, solicit, or request the video, nor did I pay for or make any promises or representation in exchange for the video or in exchange for a license to use the video. To the extent that I may have ever stated to anyone that, quote, we paid for or purchased a video, it was merely an acknowledgement that, to my understanding, a license to using the materials in the documentary had been purchased by Blackfin. I was not involved in any such purchase or payment for license or acquisition of the video. The video was shared with me by Greg Roman, an executive producer of the documentary. It was provided to me on September 9th, 2021 by means of a text message through a Signal messaging application. And then it goes on to say exactly how that happened. And then she says, in the course of my work as a journalist, gathering information for the documentary, copies of certain photographs of Mallory Beach's body taken during its recovery by law enforcement, these are the, quote, photos, were shared with me. I was not aware of the existence of the photos until I came into possession of them. I didn't seek them out, etc. I did not and have never made any promises or any representation to anyone that the video or photos would be used in any manner or for any purpose. Neither at the time the video or photos were shared with me nor at any other time did I discuss with anyone anything about harming the Beach family or attempting in any manner to affect or influence the members of the Beach family in their wrongful death lawsuit. My sole purpose in all aspects of my work on the documentary was to report the news and nothing more. And then she did say at the end, I never had any personal interaction or interest. I never had any personal interest in the outcome of any lawsuit that Gregory Parker or his business is involved in regarding Mallory Beach's death. I have never had any interest, motive, or agenda with respect to foregoing parties or their affairs in any fashion outside of their relevance, if any, to a newsworthy topic of great public interest. So that is to say that she says in her affidavit that she got the mediation video from Greg Roman, who was one of the producers of the doc.
Yes, this is what Murdoch Murders Deadly Dynasty doc.
Right.
But there's some suggestion that maybe he was hired by Parker's as an investigative journalist to work for them. That is the suggestion. I don't know if that's been sussed out totally yet.
And if that's the case, then that's what
that would make if that is the case, then someone with Parker's released this mediation document.
I mean, it's also possible that Markers did hire Roman, but they didn't give him the right to pass it on.
Right. We don't. I mean, all of that would be sorted out in this litigation, but
they're not. But he's not named.
What is saying is that possibly somebody with Parker's released this confidential mediation stuff to people with this documentary, and they included it in the sizzle reel that was supposed to be private, but someone erroneously made the link public.
It was on Vimeo.
Yes, I can't say that word, so I'm going to make you say it every time.
And so what?
But we need to get back to Liz's article.
Okay.
So this is the second article. We talked about the first article in the Wall Street Journal, which maybe says, okay, maybe Parker's people did hire people. Then the second article was Liz Farrell from December of 2021, and she links the sizzle reel to her article. And in her article, she's questioning how this production company for this upcoming documentary got this information that was included in the sizzle reel, the sensitive stuff. But she puts the link in her article. So there's a lot of questions here because, I don't know, maybe more people saw this, and she's a journalist. She has every right. But maybe more people saw this awful video that included these photos that would have never seen it had not she linked it to her article.
Yes. And again, what I'm about to say is not criticism because you're a journalist. You do what you do. What I'm saying is, though, that definitely less people would have seen it. And definitely they could have said to the people, do you know this is public? Take it down.
Well,
I'm not saying they have the obligation.
You don't have the obligation to do it.
I'm making it very clear. I do not have the obligation to. But
I think they took the link down pretty quickly. So
okay.
I don't know how many people actually saw it.
Okay.
But I don't know. Maybe you could find out how many people saw it. So there's a couple of questions here. The question is, how did Liz Farrell get this link? Is it something that she just stumbled upon? Or did someone give it to her? Was it somebody from Parker's or was it somebody from the beach defense team?
And that is a big point of contention. That's one of the biggest points of contention in all this.
That is a big point of contention because, if in fact maybe Liz got it from somebody from the beach side, I don't know. Does that mitigate damages? I'm not really sure.
Yeah, right. And if they got
or
it
maybe
from
they were
Parker's,
saying like, look at what they're doing. They're doing these terrible things.
Yeah, with that, yes. But that's the question is, and so this has been debated, and now things have come out.
Yeah. So this is okay. Now on to follow the ball because there's so many different parts to this. So there's another article. Another journalist, Mandy Matney, has filed a motion to quash her subpoena, and with that, there's been like stuff going back and forth, all of these filings. It appears as if somehow some private communications between Mandy Matney and Liz Farrell have been given to the Parker's defense team.
And they're public.
And they're public because they're attached as exhibits.
Well, I just want to make sure that people know that we didn't. I mean, they're.
Oh no. Like, this isn't this. This is straight from an exhibit, and from what I can tell, it looks like maybe a former journalist who worked with Fitz News came in, had a laptop that maybe she somehow had access. I don't ask me how technology
but it's
works.
In the exhibit,
but
that's the thing
this is an exhibit. I think it's Exhibit 9 to Parker's response to Mandy Matney's motion to quash.
Okay.
So, do you want to read what this?
The text that we have?
Yeah, the text.
Okay. So Mandy says Cinemart, who is a production house.
Yes, who ultimately made a documentary about Murdoch that was aired on Netflix.
It was called Murdoch Murders: A Southern Scandal.
Yes.
And these guys are no fly-by-night people, and they're not in. They didn't make the sizzle reel, to be clear.
No, they did not. There's no contention that they made this sizzle reel.
But it comes up in this text, and so Mandy says Cinemart, LOL. Liz Farrell says, yeah, them. And then Liz says, I mean, really, it was Mark who told me. And then Mandy says, how come the trolls come out right after we call Parker's out? An unknown person chimes in with every bleeping dime. Liz Farrell says, but he found it because someone from Cinemart saw it on Vimeo. So again, Cinemart did not make it. She's saying that someone from Cinemart, in this text, someone from Cinemart found the Vimeo and then told a Mark.
Right, because they're competing documents. We've got this Cinemark, and we've got this, and we've got the Discovery ID
did
Discovery ID documentary that Vicky Ward was on.
And the Cinemark's a different house.
Yeah, so this is just like a competing
Blackfin versus Cinemark or whatever
yeah,
it is.
Blackfin was the production company, I believe, on the Discovery ID one, and Cinemark. So I think these are just kind of two competing competitors. Maybe he just looked and just randomly discovered it, or maybe somebody just
gave him a heads up.
Gave him a heads up. I don't know.
Okay.
But so the questions are, it was Mark who really told me. We have Mark Tinsley, who is a defense attorney, but Mark is a very common name, so that could be someone else. I don't know if that conclusively proves anything. I mean, it is a little confusing when you read it.
So we have that, and then is this where we want to bring in what the attorneys from Parker said?
Oh, yes. Okay. So this is what they say. Hold on, I can't read. I don't have my readers on.
Okay, this is from
Parker's response to Mandy Matney's motion to quash.
Okay. With respect to the Vicky Ward sizzle reel, parenthesis, the publication of which is very much an issue in this case, Ms. Farrell admitted she wrote a story on December 1st, 2021, which included a link to the sizzle reel. It tells you what exhibit. Ms. Farrell claimed she could not recall how she learned about the sizzle reel, but on information and belief, Ms. Farrell learned it from Mr. Tinsley, who did not attempt to stop her from publishing her story and further disseminating the sizzle reel to Fitz News viewers.
Okay, so they're saying that's a problem. I think what they're saying, because that was where they're referencing this Exhibit 9 that we just read to you. So they're saying that is Mark Tinsley who wrote that.
And furthermore, they say he didn't stop it. So if he thought it was going to hurt them, he could have stopped it. That's what they're alleging.
That's what they're alleging. We're not saying that is right or wrong.
Yes.
We're just saying that is the contention in this filing.
So if what they're saying, so if Tinsley didn't stop it and he says it hurt them, then they're saying, then what are you yelling at us for?
Right. You by you giving this link,
Yeah.
maybe injured your client.
That's, you can sort that out. What is what?
And
okay.
you know what? Honestly, if he gave the mediation video, I think he has every right to do it because that's their work product. The mediation video that he paid and had created on behalf of the Beach family.
But that's not the sizzle reel.
But that's not the sizzle reel.
I mean, the sizzle reel, some stuff was taken out of the mediation, but the sizzle reel is different.
Right. Well, yes.
So
but he didn't create the sizzle reel.
No. But the question is, did he know about it? Did he know? Did he give it to Liz, or did he know Liz had it and not try to stop?
Right.
Or none of the above.
Right.
Okay.
Now back to the articles. We have the first Wall Street Journal article. We have Liz's article in Fitz, which had the sizzle reel. And then there's a third article, and I think this same quote was maybe used in two articles. This was from July of 2020, an article that was published in Fitz News written by Mandy Matney that used some quotes from Renee Beach that appear to be very similar, if not the same, from comments made in the confidential mediation video. Now, Mandy has been subpoenaed for a deposition. She's filed this motion to quash, which we read part of a response from Parker's on. And she has publicly stated that she was provided that quote by Mark Tinsley.
Right.
So, and then, maybe he thought that was probably her best quote because he thought it was important enough to include in this mediation video. Maybe he thought that would be a compelling quote to give to a journalist.
And again, we go back to it's his
video to
so
do.
Is he allowed to give? It seems like he'd be allowed to give it to a reporter to get a quote from, or a section of it or something. I don't know.
I don't know. But then if the reporter then used like these photos that were distressing for the family to see in media.
But if it's just a quote or something, maybe that's different.
If
people sort it out.
Right.
So obviously you see that Parker's defense team is trying to establish a working relationship with the Beach defense team and journalist.
Right.
And so they're saying, hey, you were saying that we were doing these bad things because we hired these investigative journalists, you released certain information.
We were doing things to promote our narrative or what we thought we were doing, or
pushing.
So they were pushing their side, and they're saying, hey, maybe you were also working with media to push their side. And it does seem like the fact that Mark Tinsley flew up to Baltimore to represent Liz Farrell in a deposition, they do probably have some sort of friendship,
working relationship.
Yeah, working relationship or friendship.
Yes.
And they're in the filings.
And that doesn't mean that anything.
That's what they're trying
nefarious.
That doesn't mean nefarious. Journalists have sources, but in the filings, they're trying to establish that they had, a working type relationship.
Yeah, they're saying, well, you worked with Greg Roman, Parker's. Well, you worked with those people. Blah 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 blah. And I don't.
Yeah, you work with Greg Roman to release stuff and promote your side of things, and maybe Tinsley did the same thing by working with other journalists.
Right, and so it'll be the judge who will sort it out. Okay, so is that what we needed there?
Yeah, well, okay. Yes, because we need to talk about basically reporter privilege, because I think there are some good arguments that do Liz and Mandy really have to say these things to anybody because they're journalists, and we have a privilege in this state where you're allowed, if you're working in a story, you have certain rights as a journalist.
And what are those? Well, we need an expert to tell us.
We do.
Let's talk to the legend Jay Bender. So we love having this guy back. He is the man with all the knowledge in South Carolina about how the media and the law work. He's already shaking his head. No, he's just
shaking his head. He's very humble.
He is Jay Bender. He is retired media law professor and was a big part of the Murdoch trial as well.
The media liaison, I think. Was that the official title?
I think that's what I was. Yeah.
Yes. So, well, welcome back. Good to see you again. I hope you're having a good summer. We want.
It's December. Summer is long gone.
I mean, what is wrong with you, Matt?
Oh my God, that is. I am messed up in the head.
Are you having a senior moment?
I am having a senior moment.
I think he is. He was at a holiday party last night. So
Yeah.
maybe.
I understand.
Off the air, we were talking to Jay about his motorcycle riding and everything. And I remember last time we talked to him, it doesn't matter. I'm an idiot.
Jumps out of airplanes,
Yeah.
which is crazy. He jumped out of an airplane after the age of 80.
Yeah.
He makes me scared just to think about jumping out of an airplane, and he did it at 80.
Well, I guess the videographer asked me when we were on the ground if I planned to do it again. I said, no, I'm a lot less limber at 80 than I was in my 20s when I started doing it. It was much more difficult to get out of the airplane than it had been in days gone by.
Yeah.
And you said you've done 50 jumps?
51.
51 jumps?
51, yeah.
Oh, wow.
That's amazing.
I started skydiving in the Army. And when I got out of the Army to come to undergraduate school, I couldn't afford to jump anymore, so I quit.
Oh, well, thank you for serving too. And I would imagine it's a little bit softer landing than it was when you were in the military and they had to fly low and you had to jump and those kind of things.
Well, I was never an airborne. I was a skydiver in the Army.
Okay.
And,
My father-in-law was too, and he never did it again. He developed a fear of heights after it.
well, the new parachutes are so much better than the ones we used in the 1960s. It was quite an enjoyable ride and a smooth landing.
Oh, well, that's good to hear.
Let's get into it, Seton.
Yeah, so we wanted to bring you in. We've been covering this Outrage Parker's Beach lawsuit. There's a lot of journalists who've been subpoenaed for depositions, and I pulled up an article that I read about Journalistic Shield in South Carolina, and you seem to be the guru in this. It was I just kind of wanted to do just a general history of it. I know there were some changes made in 1993. Can you give us basically some background about the South Carolina Journalistic Shield and how that applies?
Right. It's referred to generally as a privilege, but it's a privilege in the sense that legislators have privilege against defamation claims for what they might say on the floor, Nancy Mace being the most contemporary example of that. But it is a barrier to reporters having to give testimony in lawsuits in which they are not parties. For many years, there was a belief that the Constitution provided protection. And in the Fourth Circuit, which governs federal courts in South Carolina and North Carolina, there is a recognized privilege against reporters being compelled to testify based on the First and 14th Amendments. South Carolina's Supreme Court has said that that privilege does not exist, but we have a statutory privilege which is designed to protect journalists, to keep them from having to give up what they do in investigating and reporting news and information to the public to go testify in somebody's private litigation or even in a state criminal prosecution. To get a reporter to testify, the person seeking to compel the testimony has to establish that the testimony is vital to the case and cannot be available from some other source. I'm frankly surprised that I haven't heard from any journalists who might have been subpoenaed in this case. Well, I don't know about the Parker case. The case I had heard most recently about was an effort to stop Mark Tinsley, a lawyer who was representing a plaintiff in a case where a man was chased down and shot. And the Horry Police Department seemed to have no enthusiasm for investigating it. And now a solicitor from another circuit has been assigned to investigate the case. I thought that might be what you were talking about. But if you're talking about the Parker case, that's the one that came out of the boat crash down in
It's an out down in Beaufort. Mallory Beach
Yeah.
was a young woman was killed in this boat wreck, and they've settled the civil liability in this case. But there's this outrage lawsuit, which Mark Tinsley is also involved in this case. He is representing the Beach family, and Parker's.
Okay, I now know what you're talking about.
Yeah.
The crime scene, or not crime, maybe it was a crime scene.
Yeah, some pictures of Mallory
The
Beach
pictures of
came out.
the young woman's body after it was
Yes,
recovered
yes.
somehow got leaked. And so, yeah, there is that case. And I guess the Parker attorneys are the target of that litigation. Is that correct?
Yes, Parker's are, and they're kind of trying to suss out, what possibly Mark Tinsley's relationship was with journalists. Both sides, but both sides are kind of trying to seek out. I think Tinsley is trying to seek out that this person was hired, potentially a journalist hired on behalf of Parker's to kind of advocate for them. And then Parker's has kind of filed back and said, hey, you seem to also have some relationships with some journalists as well. So lots of journalists have been subpoenaed in this case. Actually, one, Liz Farrell, gave her deposition. She did not file a motion to quash. I believe there's several other motions to quash pending. First off, we should ask, if you don't file a motion to quash and you do voluntarily submit to a deposition, does that waive your privilege?
Absolutely. If you submit and answer questions, you have no claim of a reporter's privilege. So typically, reporters have two options if they want to resist. The first is to move to quash, where the reporter and the news organization would control the allegations and the motion going forward. The other is just don't show up, and then the other side would seek to compel your attendance by a contempt of court motion. I prefer the former, to file the motion to quash and argue that in advance, and then you have always the opportunity to appeal that, because once you testify, you have no privilege. So if a court were to rule against you, you would have the right to appeal that before you would be compelled to testify. I prefer that strategy and have used that effectively over the years since we adopted the South Carolina Reporter Shield Law, which in the General Assembly findings concludes that it's vital in a democratic society that the public have a free flow of information on matters of public interest and concern. And certainly a wrongful death suit would be, by definition, a matter of public interest and concern. So if there are reporters who have been subpoenaed, I'm tickled that they have filed motions to quash, relying on the South Carolina Reporter Shield Law. Now, if the case is in federal court, they would also have the opportunity to rely on the Fourth Circuit identified privilege arising under the Constitution.
I had a question about what they can get from journalists. Does the Shield Law cover them for everything, or just sources?
Well, it's not Shield Law. He said privilege.
Privilege. Okay, yeah, go.
Well,
what does it shield them from, I should say?
Calling it a shield law is fine, because that's a common identifier.
Right. So is everything, all their work product,
Yeah,
or is it certain things?
Yeah, like if you have a source that comes to you, like let's say we interview somebody, we interview you, and in preparation for that interview, Matt sent you a few texts, I made some notes, all of those things. Just because you're on our air, you're not a confidential source or anything like that. Does that matter? Like, would everything that I have be available to all?
No. The South Carolina Shield Law makes it clear that it is to protect journalists from being subpoenaed to provide information, either by testimony or giving up documents, because the very fact that a reporter is subpoenaed interferes with the reporter's ability to gather and disseminate news.
Okay.
So some states distinguish between confidential sources and information, but the South Carolina statute does not, and it provides a protection against being compelled to provide information for all information, not just sources, but even information that has been published, because our statute says the publication does not waive the claim of privilege.
So, like, if we did this interview, we put it up in the podcast, but we edit some things, somebody couldn't come to us and say, we want the whole unedited interview.
Well, they could always come to you.
I mean, but okay. But
No, we're going to.
we don't have to hand anything over.
No, and
Okay.
I urge people not to comply voluntarily.
Gotcha.
Well,
Just-
yes, like send me a subpoena or make me do it. Yes. Let me ask you this though too.
I have this desert metaphor that I use because I grew up in New Mexico and I'm used to cactus. There may be water in that cactus, but you have to go through the needles first, and a lawyer representing a reporter is the needle.
Ah.
Gotcha.
So you would need to get through the needles to get a court order to require somebody to give up information or to testify.
Well, I want to talk about this because, we have a podcast and, people get their information from a lot of different ways, as opposed to when we all just got a newspaper. What does the South Carolina say about who qualifies as a journalist?
Well, that's interesting because that's always a question. And from the earliest days of the Republic, there has been opposition to defining who is a journalist, because the most famous writer of the Revolutionary era was Thomas Paine, who was a pamphleteer. So news organizations asserting constitutional protections do it not only for themselves, but for that lonely pamphleteer like Thomas Paine. And as the South Carolina legislature was considering the adoption of the Shield Law, the question came up, how do we determine who is to be covered? And rather than identify by name or outlet who is covered, our law protects those who are engaged in the gathering and dissemination of news and information to the public. So the fact that you disseminate information to the public through your podcast would bring you within the scope of that statute.
It sounds to me that the South Carolina, this particular law, as you were talking about some of the other states, seems to be pretty well written and broad in favor of a journalist. And you kind of hinted at some other states not so much. Is that true? Do you think South Carolina's is one of the better ones if you're a journalist?
Well, I haven't compared the South Carolina statute to other states' laws. I know that there are other states that have shield laws, Georgia, for example, and North Carolina has one, I understand. There are other states that do not recognize any privilege, but there are other states, for example, Pennsylvania has an absolute privilege, which means there are no grounds that anybody could be forced to reveal the identity of a confidential source. Our statute is what's known as a qualified privilege, that if the party seeking the information can prove by clear and convincing evidence, an elevated standard, that the information is necessary, vital, and not available from another source, the reporter could be compelled to testify.
So how do they go about you? So let's say somebody has a bit of information. The party has to go and see, well, can we get this information by contacting this other person? Like the journalist is the last resort. Is that what you're saying?
Well, yes, I think that's a good way to look at it. Here's an example of a circumstance where the privilege did not work. A man was accused of murder and was being interviewed in the Lexington County jail. And there was a video recording apparatus installed in the interview room. The suspect then said, "I would like to have a lawyer." And a lawyer came in to talk to the fella, and unbeknownst to the lawyer and to the suspect, the sheriff's department continued to record the conversation between the lawyer and the suspect, which is illegal and highly irregular. And at some point near the trial, the defense team found out about this recording and thought that it might help generate publicity. I hate to say that there's a routine murder case, but this was in essence a not very dramatic case, and there wasn't much news coverage of it. And so there was an effort to get the videotape illegally obtained by the sheriff's department in the hands of reporters. And one of the reporters came to pick up the videotape from a source, and the reporter had with her her husband, who was not a reporter and in fact was a DEA agent and knew the source when the video was obtained. And so the source was ultimately identified not by the reporter, but by the husband who accompanied the reporter. I tell reporters, when you're dealing with a confidential source, go read some tradecraft spy manuals, figure out how to do it. One of my favorites is 6 Days of the Condor, which was a book. Because the attention span of people at movies is limited, it was called 3 Days of the Condor.
Robert Redford, yeah.
Yeah, follow the tradecraft there. Read the steps taken by the reporters who received the information about the National Security Council spying on Americans. And they did all sorts of things to protect the source. They left their cell phones at home. They locked their cell phones in their freezers. There's perhaps an easier way to do it.
You could find this information out, a lot of things, probably by tracking movements on a cell phone, and they could subpoena that sort of thing.
And you don't subpoena the reporter, you subpoena the cell tower.
Cell phone,
Interesting.
We saw that put to great use in the Murdoch case, but there's a device called a Faraday box, which stops signals from emanating from your cell phone. I don't want to give away any tradecraft secrets, but I have met with reporters who wanted to have a confidential discussion about records or sources, and we agreed that cell phones would be left at home, and you would travel to where we were going to meet without a cell phone, and you would not get on your cell phone until you got back home.
If you go to a comedy concert, they make you put your phone in one of those bags.
And I also suggest to reporters, if you're dealing with a confidential source over a period of time, get burner cell phones and use those and dispose of them so that there's no. Now, does this sound like chicanery? Of course it is, but there are people who will try to subpoena reporters for nefarious reasons. So if you want to protect a source, think about it in advance and take steps to protect the source. But to get back to the broader question of a reporter shield law, it is designed to protect the flow of information to the public on matters of public interest and significance. It's not to protect the reporter, it's to protect the dissemination of news, which the General Assembly identified at the time this legislation was passed as something vital in a democratic society. I'm not sure the makeup of the General Assembly today would lead to that same conclusion, and I sure as hell wouldn't want to be trying. We've tried for years to get a federal shield law,
Well, I want to talk about consequences too. So, like, I was going back to the history of it, and there was a reporter in the Susan Smith case who got some information, I guess, some confidential medical records, and got that.
Well, she got information about the psychiatric evaluation of
Yes.
Susan Smith.
Just to give a brief for those who don't know the Susan Smith case, mid '90s, Union, I believe it was in
Union, South Carolina.
Union, South Carolina. Susan Smith claimed that she was carjacked. I'm just making it short. Claimed she was carjacked. Turned out she had drowned her two kids in her car and pushed her car into this lake. So
Yes.
that's the basics of the story there.
Yes, and she was being tried for murder, and the court ordered her to undergo a psychiatric evaluation, which is routine in cases like this. And the judge issued an order that he thought would preclude anybody not involved with the case from seeing the report. But an enterprising reporter named Twyla Decker from the state newspaper somehow obtained the report and published the conclusions of the psychiatric evaluation. And that annoyed the hell out of Judge Bill Howard, who was presiding. And he called her to the stand to identify her source. And she refused. And he held her in contempt of court. And he did stay the imposition of any penalty until after the case was appealed, and an appeal was taken to the Supreme Court. And in it, the Supreme Court read the South Carolina Reporter Shield Law not to protect reporters when it was the court seeking the testimony to allow the court to enforce one of its orders. And so I did not anticipate in advance that the court would read that statute in that fashion, but it did, consistent with my belief that appellate courts very often go out of their way in high-profile cases to protect the trial judge who was in the trench at the time. But we went back up after the Supreme Court ruled that there was no privilege. We went back to court, and at that time, Bill Howard had cooled off a little bit, and he asked Twyla, he read a list of people that were subject to his order and said, without revealing your source, was anyone on that list? Was your source anyone on that list? And she was able to say truthfully, no. And so the contempt citation was dismissed. It just happened to coincide with the end of the trial, but it was dismissed. So that was the Supreme Court of South Carolina narrowing what I had believed the statute covered. Now, in contrast, we had a series of prosecutions in South Carolina of members of the General Assembly accused of taking bribes. It was called Operation Lost Trust.
Oh, yeah, I remember that.
And a senator from Horry County had received an envelope from a lobbyist who was the undercover agent for the FBI full of $100 bills. And the senator was interviewed by a number of reporters about this occurrence. And when it came time to try the senator, these reporters were called to testify. And it was in federal court, and each refused to testify and asserted a privilege arising under the First and 14th Amendment. The district judge was not sympathetic to that position and, in fact, confined the reporters over a couple of day period. They got to go home at night, but they were locked up during the day.
Wow.
And they refused to testify. And the government argued that their testimony was crucial because it was false exculpatory information from the defendant himself. because he said it wasn't a bribe, it was something else. And that case was appealed to the Fourth Circuit, and in a split decision, the Fourth Circuit upheld the contempt citation with one judge, J. Harvey Wilkinson, a very conservative judge, ruling that that was a very crabbed view of the First Amendment and that the reporter should have been protected. But at the end of the day, the Justice Department dropped the subpoenas against the reporters when it became clear that no reporter was willing to testify.
Wow. Man, you've been in the trenches.
There have been people, have you seen reporters in your period in South Carolina of kind of following all this? Have you seen reporters go to jail for protecting sources?
You mean locked up?
Yeah.
Yeah.
No, no, because very often our judges will apply the statute and protect the reporters. So there was a reporter who worked for the New York Times who did a lot of reporting promoting the invasion of Iraq. She, in my view, was a propaganda arm of the Bush presidency. And then she was asked to reveal her source on some information, and she declined to reveal it. And she went to prison or jail. She was locked up, and the New York Times was forced to try to defend her and spent a great deal of money and a lot of effort to try to set aside the contempt citation. And ultimately, I guess it may have worked out that the subpoena for this reporter was withdrawn, and she got out of jail. And to show her gratitude to the New York Times, she immediately called the competing newspaper Newsday and gave her story. And I am thrilled. I'm thrilled that she is no longer a reporter for the New York Times. I thought that she probably should have been fired for her pro-war bias in covering the lead up to the Iraq War, but that was my personal opinion, not my legal opinion.
Right.
We have like in this Parker's outrage lawsuit, the Beach family is contending that Parker's hired a journalist to advocate on their behalf. I would call that person then a public relations professional and not a journalist. I would make right, and
a very clear
like, are you a
distinction.
journalist if you are working on behalf of someone in that capacity?
Once you're paid, does that stop?
Does it stop? You're no longer a journalist, or
Well, no. Let's get back to the definition in the statute. It is one who gathers news and information for dissemination of the public on matters of public interest and significance. I think that if you are doing that as part of an operation where you are being compensated to disseminate that information, you are not fulfilling the role envisioned in the statute. That's how I would argue it, but
and we don't know that this is true. These are just the allegations. We're not saying that this actually happened.
I have no idea. I've only heard rumblings about that in the background. But let's look at it this way. What is news? It's the information that people who are doing wrong do not want you to know. Everything else is public relations. I talk to reporters all the time who get press releases from police departments that only show the police department in the most glowing light. Or then the police department will refuse to give up information supporting its glorious view of itself. And I tell the reporters, do not talk to the public information officer. Call the police chief, call the sheriff. If it's a city police department, call the mayor and say, why is your police department withholding information from the public? So don't allow yourself to be boxed out of getting information that is valuable to the public just because somebody makes it difficult. And that comes up in the context of Freedom of Information Act requests regularly. And I tell reporters, nobody cares that the government has made it hard for you to get information. What they want to know is, did you get the information? What did it show? And if you didn't get the information, why not? And should the public have gotten that information? And the whole apparatus of the press, in my view, as evidenced in the Freedom of Information Act and the Shield Law, is to allow the public to learn of information either by government, corporations, or individuals that those entities and individuals might prefer that the public not know. And the job of the reporter is to investigate and report. Now, do you compromise your integrity as a reporter when you're being paid to do that? Yes. I don't know of any news organization that would accept a piece by a reporter who was being paid by a source. Now, there's a controversy in journalism right now. A reporter who was at New York Magazine and now the West Coast editor of Vanity Fair is accused of having, I'm not sure accused, I think she's probably acknowledged that she had an affair with Robert Kennedy. Her former fiance, also a reporter, is reporting that she had an affair with former South Carolina Governor Mark Sanford.
That was crazy.
So
I read that
while
too.
profiling him as he was a candidate for president, same with Kennedy, I was shocked to hear that information because I did not recall that Sanford had run for president, but perhaps even more shocked that he was having a sexual relationship with someone and that he wasn't married at the time, so he wasn't committing adultery like he did when he went to South America.
Well, he actually went on the Appalachian Trail.
Well, that just demonstrated his wholesale lack of understanding of geography. not to mention morality.
Yeah, exactly.
Well, I want to also ask, so that was the allegations about Parker's hiring this journalist. We also have a journalist who, Liz Farrell, who has admitted in depositions that she participated, or I don't know if she didn't participate, but she listened in to a focus group in the preparation of this boat case litigation and maybe help find some participants, people to be in this focus group. She was not working as a journalist at that period of time, but then subsequently went to work as a journalist and reported on this case. Is that a problem? Are you allowed? I mean, she wasn't working as a journalist at that time.
Well, what was her role? And if her role was the gathering of information for dissemination to the public, excuse me, she would be covered by the Shield Law. But it sounds from what you've described her deposition testimony to be that that was not her role at the time, that she was somehow assisting somebody in identifying a focus group to listen to the arguments, listen to the evidence, and decide how the case might go.
That's a good point. Yeah, that's
She wasn't working as a journalist at that point, is what she's testified to. She helped find some participants for this focus group, and then subsequently she listened into the focus group. So, but she wasn't working as a journalist at that period of time, but then she went to work as a journalist and reported on this story.
Well, I think it would raise pretty serious ethical implications because she was very clearly a consultant in the initial role, and I think it might preclude her from using the reporter Shield Law in the second circumstance, because at the time she gathered the information, it was not for dissemination to the public, it was for a private purpose.
Okay.
Anything?
But, my judgment on that is based entirely on what you have described her deposition testimony to be. I don't have
Yeah.
any familiarity with what she's doing or
Yeah,
did
yeah,
do.
just what my understanding of just reading the filings and excerpts of this deposition.
But yeah, that's good. It's good
Yeah,
information.
I don't think the fact that she gathered information as a consultant would be protected by the Shield law if she subsequently became a reporter. But that might get into that might get
It's kind of a
into
murky area, right? It's kind of like one
well,
of those.
yes, it is, and it's cases like that that make it somewhat more difficult to argue for protection for those who are engaged in the gathering and dissemination of news to be protected from subpoenas and demands for documents.
It's weird because we've had a lot of debate on our Facebook page about journalistic shield, and obviously a big part of journalism is developing relationships with sources so that they talk to you freely and give information and that sort of thing. And I know that, in what you report, you choose the stories that you're going to report on and you choose the information that you're going to report on and try to make it as accurate as possible. And I guess it's the ethics of it is kind of hard because sometimes you do have maybe an inherent bias. But I don't.
If you become friends with your source or something like
Right,
that.
right. And maybe do you feel that there's a time as a journalist that you should step away?
Well, that's a human a human engineering question. I'm not
I
qualified.
know it's not a legal question. I'm just
I'm not
thinking.
qualified. Now I am old and I've been around the block a couple of times, so I would suggest that any reporter who has developed sources over time will have circumstances where there might be some reluctance to reveal information that would put the source in a bad light. That's human nature.
Yeah. You don't want to if I found out today, Matt, my podcast partner, I'm journalistic, was involved in some nefarious stuff, I would have a hard time telling.
No, you wouldn't.
Nothing. Well, I mean, maybe I wouldn't. I mean, I don't know. Maybe I would just probably throw him under the bus.
Yeah, you would. Yeah. You go for the numbers.
You've heard the joke about journalists and sources. If your mother tells you she loves you, get a second source.
That is
Good
fantastic.
advice.
Jay Bender, always great chatting with you. You can really break down the history of all these things in South Carolina and the way that law and journalism and media all interact. So it's really cool talking to you again.
Well, thank you. It's a pleasure to be with both of you.
All right.
Thank you. Stay safe. Don't jump out of any more airplanes.
As creaky as I was getting to the door of that plane, and I have to say that it was a very nice plane. It got us to altitude very quickly, and the door was quite big and easy to get out of. It's just I wasn't very limber. Some of the planes I jumped out of in my earlier times did not have doors as accommodating, and you had to go out sideways and hang onto a strut before you fell away. But this was quite nice.
Has your wife ever done any of these things? Has she ever jumped out of an airplane?
Yes, she has.
She has. Oh.
We were down in Key West some years ago, and there was a place that offered tandem jumps, and so she went up and had a tandem jump, and I rode up in the plane, and it was gorgeous. You're up above all these little islands, and the ocean is beautiful. Wow. The sand was glorious, and the sky was clear, and she jumped out, and we have videotape evidence. I don't think she had any desire to develop that as an ongoing hobby. But,
one and done.
It's one and done.
And she's very courageous. She rode across country with me a couple of times on the back of my motorcycle, which is much more difficult than riding the motorcycle itself. She trekked El Camino de Santiago de Compostela in Spain, gone several months. I guess it's about a 500-mile trek, made famous by a movie with Martin Sheen called The Way.
Yeah.
It's a movie worth seeing, and that's the pilgrimage route that she and some friends walked.
Wow. What a life. What a life.
Yeah. Well, you're both adventure seekers. I love it. Kindred spirits, I guess.
Right. That's right. Jay, thank you. Appreciate it very much.
Great to be with you. Take care.
All right.
Bye.
Take care.
He is a legend. Jay Bender. It would have been great to have him as a professor back in the day.
I can't imagine. He is one of the most interesting guests we've had.
Jumping out of planes at 81. Pretty good.
Yeah.
Pretty
I
good.
can't complain about that for sure.
Okay. So what do we got?
So with him, we talked about these motions to quash that were filed on behalf of journalists. We also have another motion to quash out there, which was filed by an attorney and a former paralegal at a law firm out of Charleston, Clausen and Stubbs. And it appears as if Clausen and Stubbs was hired to conduct a focus group on behalf of the beach in preparation for the upcoming boat crash litigation.
The civil.
Litigation. And so what's interesting about this, and they're saying work product, and I think that's probably a very good argument. They were, hired by the Beach family to conduct this focus group, which a lot of people are like, focus group? They have this perception. I think it's very normal. My dad said that. Very normal to hire a focus group.
You have, you want to see what people think. If you're going to be in front of a jury, you've got to find out what works, what doesn't work in certain areas and whatnot.
Right. But also what is interesting is I think journalist Liz Farrell has admitted she wasn't working as a journalist at the time, but she's admitted to recruiting people to participate in this focus group. And then she was able to sit in. And I think there was more than one. Focus group.
Okay. And she, either recruited or just gave some names to him or whatever.
And I wasn't totally clear. As the first one, she says she was not working as a journalist at that time.
Okay. So that wouldn't be protected is what we're saying, right?
I don't know if that would be protected, but I think the second one, possibly she was working as a journalist. But again, I'm not totally sure on that.
Just to give you a little bit more insight in what's going on, who's connected to who.
But it does definitely seem like Tinsley and Liz Farrell, they're friendly enough that he's letting her sit in on his focus groups.
They've had a long working relationship.
Yes.
And he was also defended her, as we mentioned a bit ago. Not defended her, was with her, I guess, representing her.
That's
a better way to say it.
I don't
Defending
know how. I
doesn't
don't
make
know what
sense.
you say defending when you're connected, because
Was
she's not a party to this lawsuit. She's just submitted for
The deposition.
Deposition.
And he flew there and was there for her.
Yeah.
Okay. That's a wrap on that, I think. Still more shaking out. Hopefully you're enjoying it. And you reach out to us via either the YouTube channel, Impact of Influence, on Facebook as well, and support our sponsors. We're always grateful, and we'll talk soon, friend.